Hi, my name is Sarah Connor and this is my 3 branches video.
There are 3 branches in the U.S. government: legislative, which is listed in Article 1, executive, which is listed in Article 2, and judicial, which is listed in Article 3 of the Constitution. The legislative branch is described in Article 1 of the Constitution. Article 1, Section 8 describes the joint powers in both houses, like declare war, make money, and collect taxes. The legislative branch is led by Congress. Congress is bicameral, which means it has 2 houses or 2 parts of Congress. One part is Senate and one part is House of Representatives. The Founding Fathers created bicameral Congress to settle disputes among the states. The New Jersey Plan is composed of small states. It proposed equal representation. The Virginia Plan, composed of big states, proposed the proportional representation. Both led to a deadlock. The Great Compromise created bicameral Congress. On one side there is House of Representatives, which appeased the Virginia Plan followers with population, and the Senate was created on the other side to appease New Jersey Plan followers with equal representation for each state. Senate is based on equal representation. Each state gets exactly 2 representatives. There are 100 representatives in all of Senate. The qualifications for being a senator is you have to be 30 years old, be a legal citizen of the state you represent, and be a U.S. citizen for at least 9 years. The vice president is the presiding officer of Senate. But the real presiding officer, or the one who acts like it the most, is the president pro tempore, because the vice president's only real power is to break a tie in Senate. The House is based off of proportional representation. There are 435 representatives. The larger states get more because of their bigger population. Each state gets at least 1. The qualifications for being a representative is you need to be 25 years old, live in the state you represent, and have been a U.S. citizen for at least 7 years. The presiding officer of House is the Speaker of House. The Speaker is not only the presiding officer, he or she has the power to decide which legislation is considered, and he is also the third in line to presidency if the president and vice president are unable. Senate is known as the upper house and are subject to 6-year terms. House of Representatives is known as the lower house and is subject to 2-year terms. Senators are normally averaging at 60 years, while House of Representatives are younger and averaging at 30s and 40s. Each House representative represents a congressional district. Sometimes these congressional districts can fall subject to gerrymandering. There are 3 types of gerrymandering: racial, party, and pro-incumbent. There are 3 types of representational strategies. There's 1, delegate or representational, where representatives follow the wishes of their constituents. 2, trustee or attitudinal, where they use their own judgment. Or 3, organizational, where the representative follows their party view. There are 10 general steps to passing a bill, but there can be more or less depending on multiple factors, like if House and Senate both agree, or if there is a filibuster, or what the president decides when the bill reaches his desk. The executive branch is described in Article 2 of the Constitution. The only explicit powers listed is the inherent powers, but there are 3 powers given to the president: constitutional, delegated, and inherent. There are 3 formal qualifications for presidency. He must be at least 35 years old. He must have lived in. There are 7 rules of the presidency: chief executive, commander-in-chief, chief diplomat, chief legislative, chief of the economy, chief of party, and chief of state. The president is elected through the Electoral College, which is an indirect system of electing the president. Some think he's elected through popular vote, but it always comes down to the Electoral College, which the framers used so it wouldn't be influenced by citizens. A presidential term is 4 years. Each president is limited to a 2-term limit. The only president to exceed the 2 terms is FDR, which set in place the 22nd Amendment, which has limited each president afterwards to term 2 terms, which was set in effect in 1950. There are 5 different presidential amendments that have to do specifically with the presidency. The president has powers, like appointment power of ambassadors and federal judges, the power to convene Congress, the power to make treaties with Senate approval, the power to veto, the power to preside over military, which is his commander-in-chief role, and the power to pardon. The judicial branch is described in Article 3 of the Constitution. The only court mentioned in the Constitution is the Supreme Court, and Congress is given the power to create all lower courts or remove all lower courts in the Constitution. There are 3 levels to each state and federal courts. There's district, appellate, and supreme. The U.S. Supreme Court is the highest court and can receive cases from either state or the federal side, or even original jurisdiction. The U.S. is a dual court system because it has both state and federal. The lowest court on both the federal and state side is district court, or otherwise known as trial courts. There are 94 geographically based units, and at least one in every state. Trial courts have original jurisdiction, meaning it is the first court to hear the cases. Appellate courts, or otherwise known as the Court of Appeals, is the middle court. It has 11 state courts, the 12th is specialized for regulatory commissions, and the 13th is specialized for patenting. Appellate courts have appellate jurisdiction, which means it has already been held in a district court before, and the defendant has called on the Court of Appeals, otherwise known as the appellate courts, because they feel unhappy with the Supreme Court is the highest court and has 9 justices and has had so since 1869. There's 1 Chief Justice and 8 Associate Justices that are in it for life unless they die, retire, or impeached. There are about 150 cases out of 8,000 per year. The Supreme Court has such few cases every year because the justices get to pick which cases they want. And this is where the rule of 4 comes in, because at least 4 justices have to choose to take a case on for it to be heard in the Supreme Court. The Supreme Court has both original and appellate jurisdiction. Most cases are appellate jurisdiction, where it comes up from either the state or federal side. But original jurisdiction is when cases are so important that they go straight to the Supreme Court, like state versus state cases. There are no explicit or constitutional qualifications for becoming a judge. You either get appointed by the president and approved by Senate if you're a federal judge, or you are picked by the people if you are a state judge. There are thought to be 3 types or 3 theories about justices. There's 1, judicial restraint, 2, judicial activism, and 3, strict constructionists. All 3 branches of government work together. Congress makes the laws, the executive branch enforces the laws, and the judicial branch revises or changes any laws that they find unconstitutional. All 3 branches work together so well because of the checks and balances. Each branch has at least 1 check over the other to keep each branch in line. Framers created this so one branch couldn't become too dictatorial or monarchical and have too much power.